When I was in college, our sorority traveled for an out-of-town, vaguely sporty event held on the beaches of Santa Barbara, California. We were assigned a coach from the host organization who somehow knew even less about the sport than we did and whose sole task seemed to be encouraging us to drink. It was 7 a.m. When we arrived to the actual venue, it was kind of a relief to discover a series of rent-a-fence panels blocking participants from accessing the surf. Many of us watched as one attendee had an absolute meltdown that she was not permitted beyond the fence and into the water. She was fortunate to have a firm rule imposed on the event: no drunk people in the ocean. Seamen Tucker and Kelch were not so lucky. This is Conduct Unbecoming. I'm Erin, and I'm your host. In January 2019, the Coast Guard cutter Douglas Monroe moored in Dutch Harbor, Alaska for repairs. Dutch Harbor is located on the island of Unalaska, one of the Aleutian Islands. That all means that Dutch Harbor is further south than a lot of the places at least I think of when I think of Alaska. But it was still Alaska in January. Dutch Harbor is not what we can refer to as a big town. The population hovers at just above 4,000 people, or about the same number of students my high school had. Perhaps some of you can relate. A cutter isn't a giant ship either. The Monroe hosts a crew size of about 110. When the crew cut loose for Liberty that Saturday night, many of them headed to a local bar. Seamen Ethan Tucker, Ethan Kelch, and Trevin Hunter from the deck division weren't old enough to imbibe with their buddies at the local bar. So they did what teenagers sometimes do and bummed a bottle of R&R Reserve whiskey off an of-age shipmate. In spite of the cold, Tucker and his friends caught a ride to a trailhead, intent on splitting the whiskey on the beach. They hiked down a trail and found the right spot near an old shipping container. There, they built a fire and started some music, passing the bottle of whiskey between them. Tucker and Kelch became increasingly drunk, and Kelch began to open up. He spoke to his shipmates, his friends, about the challenges he'd confronted in his young life. Tucker weighed in, sharing the things that he'd struggled with. And the conversation devolved into bickering over who had it worse. Kelch became upset by the turn the conversation took, and his friends tried to comfort him. Instead of talking more about his feelings, he began to kick at things, picking things up and throwing them. Kelch kicked around the fire before grabbing bits of wood from the fire and throwing them out the window. Legal Beagle, I have no idea where a window got involved. It is possible, but it's not clear, whether there were windows cut into the shipping container or whether they lit their fire within the shipping container itself. Nevertheless, somehow there's a window. Tucker and Hunter tried to calm Kelch down, and Tucker reached out and put Kelch in a bear hug, which devolved into a headlock. Kelch fought back against the physical restraint, and both he and Tucker fell backwards, where Tucker hit his head on the shipping container. Some articles describe this as Kelch hitting his head on the shipping container, but I'm going to go with what the opinion says, because it also makes the most sense to me in terms of Tucker being behind Kelch. He would be the first to hit the shipping container in a fall. With the night devolving into physical altercations, the three knew it was time to hike back up and get themselves back on board the ship. They packed up and began the trek back. But as a cold January rain fell around them, Tucker and Hunter realized Kelch was no longer with them. They called out, looking for him, and eventually found him lying at the water's edge, the waves gently lapping at him. Kelch wanted to go for a swim. The water may have been gentle, but Kelch was not. It's argued later that Kelch was known to become aggressive and belligerent while drinking. As he laid there on the rocky beach with the water all around him, Kelch began yelling incoherently. Tucker and Hunter spent at least 30 minutes trying to get Kelch up and to get him to walk back with them to the ship. When that didn't work, the two decided the time for talk was over and it was time for action. They grabbed Kelch and tried to hoist him up and drag him away from the water and towards safety. Kelch flailed in their grasp, breaking free and again falling to the ground, then he rolled back towards the water. This seemed to be the breaking point for Tucker, and he couldn't contain himself. He straddled Kelch, grabbed him by the lapels of his jacket, and yanked him forward. He bent down so they were face to face, and Tucker began to beg Kelch to stand and walk back with them. Kelch declined. Tucker punched Kelch in the chest and the side of his face a few times before Hunter intervened. Tucker got off of Kelch and climbed up the bank, away from his friends and the 38-degree water. When he found the grass along the shoreline, he took a little lie down, nursing an injured hand. Some of the night's interactions were captured on Snapchat videos, which I don't entirely understand. Sure, the drinking and the bonfire are pretty common topics for social media stories. That's not where I get lost. I get lost at filming the attempts to remove Kelch from the water. While I do think it's fortunate for Tucker that so much of the night was documented, I also think using two hands and not filming may have been a little bit more helpful. With Tucker passed out, Hunter tried to drag Kelch himself, but he kept slipping and falling on the rocks. He finally found purchase using Kelch's belt for leverage and used it to pull him as far up from the waterline as he could. Neither Kelch nor Tucker was moving. Hunter took a moment and caught his breath. He returned to Tucker and yelled that he was going to the ship and he was going to get help. It was a cold 45-minute walk back to the boat. When he arrived, Hunter told another coastie about what happened that night and what kind of assistance he needed. The shipmate gathered two others and grabbed a ride to the trailhead from the duty van. They located Tucker, who was still lying on his back in the grass, asleep. They shook him awake, but he was incoherent, cold to the touch, and soaking wet from the cold rain. A shipmate gave him the literal clothes off his back to warm him up, and they moved him into the van. As Tucker's focus returned, he grabbed one of his colleagues by the collar and began repeating that they needed to find Kelch. They had to go save Kelch. When the search party found Kelch, he was unresponsive. They brought him to a local clinic where he was pronounced dead. He showed signs of head injuries, but ultimately the coroner found that the head injuries were superficial and non-fatal, and that Kelch drowned. At some point during this investigation, Tucker told investigators that he'd injured his hand not by punching Kelch, but by punching a steel bulkhead after learning of his death. The scrambled and partial retelling of the night's events created a distorted timeline of events, and prosecutors initially believed Tucker, who'd tried to choke out and subdue Kelch and punched him in the head, had placed Kelch in the water face down and left him there. The Coast Guard transferred Tucker to the Coast Guard Base Alameda, near San Francisco, to work in base security while they conducted an investigation and decide whether to charge Tucker for the actions he took January 26, 2019. Nearly 8 months after the incident, Tucker was arrested and moved to the Naval Consolidated Brig aboard the Marine Corps Air Station Miramar for his Article 32 hearing in a borrowed courtroom at Marine Corps Base Camp Pendleton. There, Tucker's attorneys presented evidence about Kelch's drinking persona and began to build their defense. Initially, given the scattered retelling, the government charged Tucker with murder and manslaughter, and a variety of more minor offenses. But following the Article 32 preliminary hearing, they amended their charging documents to remove allegations that Tucker placed Kelch in the water. The government made Tucker an offer. If he accepted a plea agreement, they would withdraw the murder charge, and instead they would refer two other specifications, one for negligent homicide and one for an unenumerated Article 134 offense, alleging a series of acts that contributed to Kelch's death. Tucker made that plea agreement, and in accordance with that plea, the military judge convicted him of violating a lawful general order for the underage drinking, making a false official statement to investigators about his hand, and taking actions that contributed to Kelch's death. The judge acquitted Tucker of negligent homicide and of involuntary manslaughter, but convicted Tucker of one of the lesser included offenses, assault consummated by battery. The judge sentenced Tucker to confinement for 14 months, a reduction to E1, and a bad conduct discharge. On appeal, Tucker raised 7 assignments of error. 2 of them revolve around the unenumerated Article 134 specification. The rest are pretty standard flavors of inappropriate severity, delay, undue command influence, and a biased prosecutor. Just a reminder that just because a prosecutor is prosecuting doesn't mean that they're biased. I'm most intrigued by the issues around Article 134. Article 134 of the Uniform Code of Military Justice reads, "Though not specifically mentioned in this chapter, all disorders and neglects to the prejudice of good order and discipline in the armed forces, all conduct of a nature to bring discredit upon the armed forces, and crimes and offenses not capital of which persons subject to this chapter may be guilty, shall be taken cognizance of by a general, special, or summary court-martial, according to the nature and degree of the offense, and shall be punished at the discretion of the court." That's a really long sentence. Article 134 punishes acts in 3 categories of offenses that aren't specifically listed in other articles of the UCMJ. The first category are acts that directly prejudice good order and discipline. The second category are acts that damage the military's reputation. And the third category includes acts that violate other laws, but that don't rise to the level of capital offenses. I think this third category makes the most sense to me from a few perspectives. It incorporates other law, but it's clear that capital offenses must be enumerated offenses. We don't and shouldn't impose the death penalty for crimes we didn't care enough about to list. The first 2 categories feel a little bit fuzzy to me, but they're a catch-all, and I suppose that's kind of the point. Tucker's appeal asserted that the Article 134 specification failed to state an offense, and that the judge shouldn't have accepted his plea to the Article 134 specification. Technically, Tucker phrased it as the evidence being factually and legally insufficient. But this was a plea deal, and that means there wasn't a judge or panel weighing the evidence. It was an assignment of error that didn't quite make sense, so the court did some editing to state it a little more clearly. During the appeal, the government argued for the very first time that Tucker breached some known duty of care to fellow service members. So let's look at all of this under the 3 categories listed in Article 134. We don't get to count things like drinking underage or the assault consummated by battery or the false official statement about how he hurt his hand, because those were all specifically chargeable and charged offenses. I think that just leaves us with trying to carry Kelch away from the waterline and then passing out. First, acts that prejudice good order and discipline. While nearly any act can be sort of prejudicial in a really remote sense, we'd have to look at whether what Tucker did on the beach did direct harm to good order and discipline. Neither trying to carry Kelch from the water's edge nor passing out directly erodes good order and discipline. Second, we ask ourselves whether this is an act that damages the military's reputation. Trying to get Kelch to safer ground and passing out aren't acts that embarrass the Coast Guard. Neither of these actions caused the Dutch Harbor residents to negatively view the entire Coast Guard. Finally, we look at that category that incorporates other crimes. Neither act constitutes a federal crime, a state crime, or some other crime known only to the residents of Dutch Harbor. While the article is a catch-all, the highest military court has previously ruled that it's not such a catch-all that it makes every irregular, mischievous, or improper act a court-martial offense. And that makes sense intrinsically because in order for something to be prosecutable under Article 134, service members must be on fair notice that their conduct was punishable. While much of Tucker's conduct that night on the beach was punishable and was, in fact, punished, what we're left with when we remove that conduct just wasn't. If there was some duty of care Tucker had towards Kelch that he violated, it wasn't one that he had fair notice of. Even though the government argued on appeal that such duty was known. There is a lot of anecdotal evidence about service members caring for one another, but that doesn't make it mandatory. And separately, even if it was mandatory, I don't know what else Tucker could have done that night. His first words upon coming to were a direction to find Kelch. The Coast Guard Court of Criminal Appeals concluded it was an abuse of discretion for the judge to accept Tucker's plea to the vague Article 134 specification. They reasoned that the plea and conviction were for non-criminal conduct, for conduct that wasn't illegal. I think something specific that is often misunderstood about criminal justice is the saliency of errors. Very few trials are perfect, but not all errors are a problem to the effective administration of justice. What it comes down to is whether the error was prejudicial, whether the error was meaningful. It's pretty clear that an error resulting in an extra conviction was prejudicial and had an impact on the sentence Tucker received. Because the error was prejudicial, the court set aside Tucker's Article 134 conviction. Both Tucker and the government requested the court to reassess the sentence themselves instead of authorizing a rehearing. The court was reasonably confident that absent the error, Tucker would have received a sentence of at least reduction to E1 and confinement for 6 months, shaving 8 months off his confinement period. The court concluded, though, that neither underage drinking nor making a false official statement merit a bad conduct discharge. The court had to consider whether assault consummated by battery was sufficiently egregious that it would merit a punitive discharge. They concluded that what they had on their hands was an assault consummated by battery driven by frustration, not malice. They had a drunk young man who punched his drunk young friend after trying to stop the drunk friend from rolling into the ocean. Given that, the court wasn't confident that a bad conduct discharge would have been ordered, and approved only the reduction in grade and confinement for 6 months. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we peel back the veil on domestic violence. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct and Becoming is not approved, authorized, or endorsed by the Department of Defense.